case briefs, and so much more. LSData's got what you're looking for.
In 1962, the Texas Courts of Civil Appeals heard a case that delved into disputable territories of contract laws, Martin v. Darcy. The case centered around the legal principle that, when a contract is breached, the guilty party must cough up not just for the damages that naturally spring from the violation, but for those damages both parties could have foreseen when inking the deal. One caveat, though: to claim lost profits, the plaintiff must lay bare that such profits were a shared expectation when the parties first signed on the dotted line. Caught in this contractual tussle were Harris P. Darcy and Glen A. Martin in a fracas over a farm-out agreement. Darcy, owning mineral rights to 671 acres of land, committed them to Martin under the condition that Martin would drill a well there. Yet Martin balked on fulfilling his part of the agreement, presenting the lack of necessary permits from the oil companies as the hurdle. In his corner, Darcy argued that the lack of a well, which turned out to be a bust, entitled him to $3,500 as per the contract. Martin, however, claimed that Darcy had in fact violated the agreement, failing him by not securing the essential approvals. Both the contract agreement and the breakdown of it were laid out before the trial court, where both parties presented their arguments. The decision tilted in Darcy's favor, granting him $3,500 in contract damages. Moreover, the trial court found merit in Darcy's claim of profit loss, carving out an additional $3,000 in his favor. Not satisfied with this verdict, Martin appealed against it. The Court of Civil Appeals dived into the previous proceedings, finding errors marred the legal instrument interpretation and lost profit calculation. However, the court upheld the breach of contract verdict, agreeing that Martin, by missing the set drilling date, had indeed violated his contractual obligations to Darcy. Deliberating on this contractual mess, the court reaffirmed the initial $3,500 damage award, but overruled the additional $3,000 for lost profits granted to Darcy. The cost of the successful appeal was to be borne entirely by Darcy, closing this chapter of contract law interpretation in Texas.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind, leave the stress of class.